and one of them kind of set him up. I believe it was Mr. Senior, in fact, said that they wanted to come over his house. I don't know why, to hang out or whatever he told them. But when they got there, the victim ended up being robbed at gunpoint.
What is the defendant? He's how old? 16?
Judge, I have major disagreements with you want me to talk about that now, or?
Is that your co-counsel in the background?
Yeah, he's very helpful.
All right, tell me, I understand you dispute the facts. I want to hear from Ms. Singleton. Good morning.
Good morning, Your Honor. The defendant's juvenile history is as follows. He has a February the 21st, 2018 ungovernable that he unsuccessfully completed the CHINS program on that, which is a program that steps in and assists the families and the juvenile if there's an unruly or an ungovernable. He has a March the 15th, 2018 truancy that CHINS assisted with and closed that case. He has a May the 23rd, 2019 theft by receiving, which was adjudicated delinquent by a plea, and he was placed on probation. He has a May the 28th, 2019 simple battery, which involved him hitting another student in the face in middle school. He was continued on probation with that case. He has a violation of probation from December the 30th of 2019, which was adjudicated delinquent by a plea. And he has one second, Your Honor, they had sent me a new history, so I just want to make sure I'm correct on this next case. A February the 18th of 2020 terroristic threat, which was against a young lady that he was familiar with. That's all the juvenile history that he has, Your Honor. He was last in the 9th grade. He's 15 years old. He'll be 16 in September, I believe. He was last in the 9th grade at Westlake High School, where I believe he and a co-defendant and possibly the alleged victim all may have attended school there. He was tribunaled out of Westlake on November the 19th. He had been skipping classes there, but I believe that the tribunal was more about one of the cases that he had. He was working on online classes through a discovery program at the time of his arrest. If he were released, he would return home with his parents, Your Honor. His father has been actively involved in staying in contact with me. There is one co-defendant that I believe was taken into custody. I'm not sure if there was anyone else, but that person was already granted a bond and is out under my supervision.
All
Okay.
right. Max?
So, Judge, not great for the history, but I'll point out that, we got 2 truancies from over 2 years ago at this point.
The
Then we
ungovernable means his parents can't control him.
Well, and that was 2 years ago, and there's a battery from over 1 year ago. But this is what I'll say, Judge. The facts of this case don't make any sense, okay? And it doesn't take a person that's been doing this 15 years to see that. Someone out of law school can see that the facts don't make any sense. The alleged victim and my client were friendly. They're friends, okay? They corresponded over Instagram. My client went invited over to the victim's house, the alleged victim's house. The alleged victim in his own statements walks with my client and Mr. Dem, who's out on bond and who is innocent, and walked to a car where 2 other individuals were. The other individuals inside this car ended up hitting the victim allegedly with a gun. I believe that's correct, and took his $1,000 shoes off his feet and what he says is an $1,100 iPhone. I submit to you, if my client was wearing $1,000 shoes and had an 1100 iPhone, his stuff would probably have been taken too. He wasn't wearing $1,000 shoes. Okay, but the victim knows why he was meeting Mr. Senior. He's not being honest about it. He's not being honest about why they were meeting. He's not being honest about why Mr. Senior, the victim, and Mr. Dem were all going to meet the two guys at their car with $10 in their pocket each, and what they might have been doing and buying for activities after school. And that's fine. He doesn't have to be honest about it, but it's going to come out. And there was a robbery. Nowhere in the victim's statement did my client put any hands on the alleged victim, nor did the co-defendant. It would take me 6 hours maybe to determine the identities of the two actual robbers in this case. Okay, but no one's done that. Everyone's focused on Mr. Senior, who didn't do anything other than he was going to make a purchase along with the victim from the robbers.
Of drugs.
Well, okay, well, I guess there are three peas in a pod
All right,
then.
let me hear from the father.
But so, and Judge, I'll say this, one other thing. Mr. Senior's been in since February 18th, okay? And, school, from my understanding, from talking to Ms. Singleton, school has been a little bit chaotic, maybe in the metro.
Your client doesn't want to do what's right. He's ungovernable. He's had way too many contacts with the juvenile criminal justice system. It means his parents cannot control him. Is that what, Ms. Singleton, is that what ungovernable means?
Hello.
Ms. Singleton?
I think Miss Singleton is frozen. But Judge, if I could just for a minute.
Yeah,
I mean,
Go ahead.
ungovernable, Ms. Singleton, means that he won't do what his parents tell him to do.
typically it means that the family went to juvenile court for some assistance. I can state that.
Because
They needed some
controlling.
assistance in something, and he was placed in a program.
And he
His
was
dad is
afraid.
right there, Your Honor.
Well, Judge, my question would be, how long is he ungovernable? If I was ungovernable at 16, like, am I allowed to take part in this Zoom call? I mean, that was 2 years ago, and at some
Hear from
point,
the father.
Raise your hand. Yeah, go ahead.
Hello. Can you hear me?
Yes.
Yeah, he was off his medication because we didn't have his medication when he was getting in all that trouble. And we got him.
He's still in trouble.
Huh?
He's still in trouble.
Oh, well,
No,
he just got back on his meds because
There's
he
no
was getting his meds.
excuses for this conduct. Ms. Singleton,
Yes, Your Honor.
I can't imagine you thinking this is a good risk to take.
Your Honor, I'm not able to make a recommendation based on the history.
This is a
I
bond.
will follow whatever the court orders.
Judge, if I may, I also spoke to the detective on this case for a long time yesterday. She believes that the defendant is involved in criminal gang activity.
well, this is,
To, get his name out on the street and build some kind of credibility. And that's why he's had this series of run-ins with the law, and it's gotten progressively worse from his juvenile record to now armed robbery. And we never said that Mr. Senior actually hit the victim in this case. We said that he set the robbery up. So he's being charged as party to a crime.
He's got quite a resume for being 15 years old. And the best indicator of future conduct is the best prediction of future conduct is the right word, is past conduct absent some positive intervening action. And there's no way that I can in good conscience grant this defendant a bond, so it's denied. All right, call the next case.
okay, can I just put this on the record?
You may.
First of all, I object to any testimony or any hearsay about some gang activity through really double hearsay at this point. If that investigator is so, and this can go on the record, that investigator is so in tune with this case, then that investigator needs to spend 3 hours to figure out who's the individual that pistol whipped the victim and who's the individual that pulled a gun on the victim. Because I can figure it out. It's not hard. And I don't need my client to tell me that because my client doesn't know them.
Well,
But it's not hard.
It is my earnest belief that this defendant will get out and commit more violent crimes. That's the basis for the denial of the bond. Yes, sir. You want to say something?
Well, Judge, let me speak. Mr. Black, well, let me speak. I'll just say that what I was trying to explain earlier, Judge, is he's been in there since February of 2020. So right now we're at about, 4+ months. And from my understanding, he has not been receiving any sort of disciplinary reports or anything else. And to deny bond at this point, I just want to point out to the judge, I respect your decision, and these are tough decisions, Judge. I get it. But my client doesn't have speedy trial rights. My client doesn't have anything right now. He just gets to sit. He just gets to sit for the foreseeable future.
Ms. Chenault?
Yes, Judge. And despite him not having speedy trial rights right now, we do respect that. However, it's our contention that the defendant will continue to commit
Ms.
crimes.
Chenault, I apologize.
All right, Ms. Chenault, please repeat that.
Oh,
Ms. Chenault,
yeah.
I'm sorry to speak over you.
Oh, go
It
ahead.
appears that Metro's been kicked out of the call. I apologize.
Oh, okay.
It appears that the defendant is no longer on the call. He got kicked out.
April, can you help with that, please?
They said that it says waiting for host to let them in.
Is that it now? Can you see?
I'm just saying, he's held other nights. He's on the other. Then I had my house. Just sit and he was.
Yeah, but my duff will fall down, bro.
He did everybody else.
All right, they're back. What did you want to say, Ms. Chenault?
Yes, Judge. I just wanted to say that despite the defendant not having a speedy trial right now, we respect that. However, we believe that the defendant is a danger to the community. We also believe that he's a danger to the victim and his mother in this case. He has the potential to threaten the victim. He does know the victim from school. So therefore, we consider him to be a danger to the community and a potential threat to the victim.
Right. It speaks volumes to me that Ms. Singleton, who's evaluated this case, is not taking a position that she would welcome monitoring him. Does that make sense, Ms. Singleton?
Yes, Your Honor. That is
I
correct.
can't take a risk. It's my earnest belief, and I'm making a finding that I would believe that he would commit more violent felonies if he was out. And y'all can sort it out with Judge Whitaker with regard to any alleged gang activity. Ms. Chenault, I assume the detective will get back to you on that.
Yes, Judge.
All right, the father wants to say something. Go ahead.
I was just saying that, he's a pretty good kid. He was getting in
He's
trouble.
not a good kid.
I mean-
Every father's going to come in here and mother's going to come in here and tell me their kid's a good kid. He's not one. And you couldn't even control him. That's why you had to get help from juvenile court. Let's be honest here.
Yeah, he was off his medicine and everything. So now he's getting himself back together. He need a change. He need a chance. I say let him come home.
He had all the chances in the world.
Hold on.
I give chances out every day. This one, he's not getting a chance with me. So bond is denied. Let's move on. What's the next case, Ms. Woods?
Damn, they got that judge. He's not getting a chance. What the fuck? So y'all leave now.
I believe the defendant wanted to address the court. Is that correct? Does the defendant wish to address the court?
I don't think so. I think that was his father.
All right, what's the next case? Ms. Woods? April? April?
Sorry, Judge. I'm up here talking to you. I was on mute. Let me see if I can get the jail
What number next?
on it online.
I think we're doing the restitution.
We're if either the restitution hearing or I need to wait for Miss Mull, but I'm looking for the jail actually, and I don't see them. Judge, give me a second. Let me call the jail to see if we can get everybody on.
No, that'll be it. Thank you. Thank you.
Hey, Judge.
Yes.
I just spoke with the jail. They said give them a couple of minutes and they'll have someone on for us shortly.
Okay, thank you.
All right.
Max, you still have to talk to Rockmore, right?
Yeah.
Okay.
Is he?
I think
Is he?
I don't think he's here. Miss Akpala is here. So I'm gonna ask April for a room when April comes back so I can talk to her.
Can you just kind of clarify to the extent you can about, well, I guess we're clarified from your end, I guess.
Yeah, I'll be asking for 3,500, which is the Kelly Blue Book value.
3176.
3176. Let me put in my phone so I don't forget.
Golly.
3176. Okay.
I need you as my auto broker.
Right. Let's see. I thought she was on here. Like, do you know if Miss Akpala got off?
She was supposed to get off and get right back on because she said she was having trouble hearing.
Oh, okay.
Let me see if she was able to get back on.
I can hear you now.
Oh, okay. I see you right there. Okay. Miss Akpala, I'm going to ask if we can have a separate room to talk.
Okay.
So when April comes after that.
Okay, who needs a separate room?
Oh, hey, April. Me, Miss Akpala, it says Justina's iPhone, and Blake, please.
Okay, let me see. We really don't have that kind of. Okay.
It's okay if we. I didn't know.
I mean, Marietta Annex. Who is this?
That's gonna be Rock.
I got Mr. Banks ready.
Yeah, that's position number 3.
Okay, we have Mr. Banks ready?
Yep.
Okay, let me get, oh,
And we have Rockmore.
well, I think Ms. Chenault wants to speak to the victim and the victim's advocate. So if I can get Ms. Mull on the line, then we can handle the Banks and Kamaya Street case while Ms. Chenault is talking to, talking to the, yeah. So that we're not wasting anyone's time.
Is anyone here from Michael Hart? Could you identify yourself if you are? Okay.
Nobody's here for Michael Hart.
Okay.
And what about LaRon Anderson?
I already told LaRon that
Okay.
he could go.
Okay. And Judge is here, Candace is here. Is Mr. Abadi here?
Yes, Judge. Or yes, April, I am, or Ms. Woods.
All right, what are we working on now?
Judge, I was really trying to get the other attorney in on the Banks case so that Ms. Chenault could go into a breakout room and discuss the restitution piece with the victim on position 3. I'm waiting to hear from Ms. Kareem, but I guess in the meantime we can do that. And sir,
Which one, please?
Ms. Chenault wants to go to a breakout room to discuss the restitution matter in position 3, and that's Mr. Rockmore's case.
And Ms. Woods, could you put myself and Mr. Rockmore in a breakout room as well?
Okay, so hold on. And that's Marietta Annex, correct? Yeah.
Right.
Okay. Okay. And then, did I do it right?
Yes, thank you.
You're welcome. Hello. Yeah, I see him now. Thank you so much, and thank you for your patience. This is my last. All right, bye-bye. Who am I moving now? Miss Chenault?
Yes, Miss Chenault.
And
Miss Justina.
And who else?
Blake.
Justina?
Yes, ma'am.
And Blake, correct?
Yes.
Okay. All right.
Thank you, Ms. Woods.
So now we're waiting on Ms. Mull to get on. As soon as Ms. Mull gets on, we can get started with this big bond hearing with Cortez Banks and Kamaya Street. Hold on for a second.
Are we ready, Ms. Woods?
Judge, I'm waiting on Ms. Mull because I don't want Mr. Abadi to have to go over the facts all over again.
Can we work on something else?
Give me just a second. I'm trying to find her number. And people are still coming in. Hopefully she'll see me calling. She's signing on, Judge, so we'll be ready. Mr. Abadi,
Yes, Ms. Woods.
are you near your cell phone?
Yes, Ms. Woods.
Okay, I'm gonna call you.
Okay.
Are we ready now?
Okay. Can we please make sure that all phones are on mute? Because I don't want to have to put anybody out of the room. Also, please do not speak over one another. Ms. Sanders is taking everything down. And when you all speak over one another, she hears nothing. And we want to make this record as clean as we can. I believe all parties are present. Ms. Mall is here. Ms. Primovic is here. Mr. Banks is here. Judge, are you ready?
I hit Alt and Tab.
Okay. Are you? Okay.
Hello?
Judge, this is position 6.
Wait a minute. Same time.
Please make sure your phones are on mute, except for the parties that will be speaking.
All right,
That's the attorneys and the judge.
I'm not hearing anybody.
Okay, well, you take your phone off of mute and you should be able to hear us. We can hear you and we can see you.
All right, which number is this?
Judge, this is position 6, State of Georgia versus Cortez Devon Banks. Ms. Mull actually called early this week and asked to be added. She represents Kamaya Street. She has waived her client's presence, and this is indictment number 19 SC 172396, and it's on for reconsideration of bond.
All right, Mr. Abate, the facts, please. You got to unmute. You got to unmute.
All right, Judge. This is the third bond hearing for this case. The first happened on January 27th of this year, and then the second was on February 18th of this year. The brief recitation of the fact for this case is on July 16th of 2019, around 1:40 in the morning. Earlier in the evening, there had been a gambling game near the incident location, which is 765 McDaniel Street. Miss Kamaya Street was at the gambling game. She had lost some money. And after she had lost some money, she left the apartment where the party was, called her friends, Mr. Banks, Mr. Gilstrap, and the other co-defendants, Mr. Brantley and Mr. Wells, picked them up in her vehicle, brought them back armed with guns. They get out of her vehicle, which is on video surveillance, and go into the parking deck and gun down the victim in this case, Mr. Etanine Hubbard. Just open fire on him and then run back into her car. She lets them back in and they flee the scene. And Mr. Etanine does not survive the injuries caused from the shooting, based upon the revenge of the fact that she wanted the money back that she had lost at her gambling game. That's the short recitation of the facts.
So you think she was the impetus behind this armed robbery?
She was. She was she called them, she brought them, and she provided the motive in which to gun down Mr. Etney due to the fact that she had lost some money at the party and she wanted it back.
She was present when the shooting occurred?
She was present. She was the driver, and it happened, feet from her vehicle. They exited her vehicle with a long gun, submachine gun is what it looks like from the video, as well as other handguns, shot Mr. Etney, open fired, and then ran back into her car.
Do we have anybody here from the victim's family?
There's about 30 members of the victim's family on the Zoom hearing. His father, Mr. Christian Etney, is on the call, as well as the entire Hubbard family, which is his mother's side of the family.
Okay, would the family members please unmute? Would family members please unmute? That's this lady and this gentleman. I'm very sorry for your loss. You have my heartfelt sympathy. God bless you. Please tell me.
Thank you.
What you want to tell me?
Excuse me, before we get started with that, Judge, can we need to handle this one at a time, so can we let the mother and the dad speak, and just let's put their phones on mute and let the mother speak. So only person that should be speaking is mom. Everybody else's phone should be muted because the background noise is going to be very challenging for Miss Sanders.
Yes, ma'am.
Okay, thank you.
We want to hear from this lady right here. Miss, please unmute.
Hi, can you hear me?
Okay, I can. I'm very sorry for your loss.
And Miss Hubbard, would you state your name for the record, please?
Mayani Hubbard.
Okay, and if you'll spell that for the court reporter.
M as in Mary, A-I-Y-A, and like Nancy, and like Nancy, I-E.
Where's Miss
Last
Paul?
name,
I'm here, Judge.
Okay.
And the judge was wanting you to tell him what you thought about bond as it pertains to these two defendants.
This is the third time I believe they're trying to get bond. I feel just as strongly, if not stronger, about them not getting bond as I did in the beginning. Life has not changed. For me, the threat that they have imposed onto my family internally will never go away. The fear I have for others and for other mothers to experience what I'm experiencing now is not an option. And they do not deserve bond. Their actions have led to an eternal fate. An eternal fate for not just my son, but for my whole family.
God bless you. Let me hear from other members of the family, please.
Hi, Judge. I am Christian Etienne, spelled Christian. Last name spelled E as in Edward, T as in Tommy, I-double-N as in Nancy, E. I am the father of Nashim Etienne, and as Mom stated, this is the third time that we are going through this, and quite frankly, I just don't even understand why we still have to go through this as a family to hear or talk about these senseless act of violence by these cowards and thugs that happened to my son. I can't even imagine. I can't even tell you how this changed my life and the change the life of our family. My son was loved by so many, and at 21 he was so respected because of his character. He had so many big dreams that we can't never experience or imagine how far he would have went. Due to these guys and their actions, Mr. Cortez Banks, we won't have this choice. The joy was taken away from us completely. And again, they are known and proven gang members. They are known for violent crimes, pretty much all of them. And Cortez was seen on video with getting out with the gun. He is the one of the alleged shooters because he was identified. This is causing nothing but pain and wounds to us having to go through this over and over again. It just doesn't make no sense. I think at this point, instead of putting us through this over and over again, let's get a trial going. Let's put these guys in front of a jury, these thugs, so we can get some justice for our son. These kind of things that we have to go through is nothing but painful, that we have to not only live, but we have to repeat and see their face. I don't want to see their face until they're in front of they are in front of a jury and they're on trial. This is hurting. There's enough going on around right now to that's we're looking at every day, and then we're still experiencing this. I say no bond. They are a danger to the community. They might be a danger to your kids, to people that you know personally. They have done this before. According to testimonies that I've heard, one of the guns recovered from one of the guns was used in a different case. So I don't see why we're here again to discuss bond. No bond, please.
Thank you, sir. Mr. Body?
Yes, Judge. I believe that's all the members of the family that like to speak.
No, that's not it.
Yes, ma'am. I'm very sorry for your loss.
Thank you. My name is Andrea, Andrea Hubbard, Hubbard. I am Nashim's aunt. I haven't spoke yet because every time it's just too hard to find words to convince the court for no bond. Once again, I feel like my brother, Chris, Nashim's father, pretty much, and my sister, Bayani, pretty much gave the court all the words and spoke for all of us. But I just felt compelled at this moment to just show the pain, of course, our children's lives completely. My son, who's my son and my nephews, like, we're all broken. The pain's too deep to explain. But as Chris said, just we're tired of this. I'm ready for the trial as well. So we don't have to keep on every time. It's just like it's like the morning of that we found out all over again every time we have to do this. And it's like will mess your nerves up and make you feel I'm sick, we're ill, we're shaky and weak. We can't function. Like this just has to be over, even though it won't be over for us completely. So yeah, that's all I pretty much want to say is no bond, and we are all ready to move forward and just put this, whatever we can, put behind us.
God bless
Thank
you. I'm
you,
very
Judge.
sorry. I'm
Thank
very
you.
sorry for the family for your devastating loss. God
Thank
bless
you.
Mr. Abate, then Ms. Mull.
Excuse me, Judge. I'm sorry.
All right, will you tell me the records?
Yes, Judge. Mr. Banks does have some felony history. He did have a juvenile robbery disposition back in 2014. From there, he has a 2016 or 2018 entering auto and possession of tools for the commission of a crime out of Cobb County, which he is currently on probation for. He also, again, out of Fulton County.
Tell me again, what was the probation in Cobb County for?
Yeah, entering auto and possession of the tools to commit the commission of a felony. So the tools for committing the entering auto. He also has a theft by receiving a handgun here in Fulton County, which is 18 SC 157917, which was resolved on April 2nd of 2018. And when this crime occurred, he was currently out on bond for a state court case for battery against a pregnant female. He currently also has a hold from Cobb County to be sent back to the Cobb County jail, where he'll have to deal with his probation violations out of Cobb County for the case I mentioned that was resolved in early 2018. Miss Kamaya Street doesn't have a felony history, but I would bring to the court's attention the way that all of this incident got moving and occurred was because of Miss Street's actions. Because of all that, we would submit to the court that she's a danger to the community and the people in it. I'd also submit to the court she is a risk of committing felonies pending trial. At the last bond hearing, I showed Your Honor pictures of marijuana, as well as Miss Street throwing up different types of gang signs. As Mr. Christian did indicate, the 4 boys are members of the Inglewood Blood family gang, and Miss Street is seen in several photos throwing up gang signs as well. In addition, Your Honor did look at parts of her phone dump at the last hearing, where the day of and the day before, Miss Street was selling marijuana as well as selling stolen firearms.
Ms. Moll, you represent Miss Street. You need to unmute, please.
Sorry. Good morning, Your Honor.
Good morning, Ms. Moll.
We contest the facts mightily in this case. I did not see any evidence of a phone dump where she was selling weapons. There was evidence that she was selling perhaps marijuana, but that's it. She has met the Ayala factors. She has no record, Your Honor. She is a student, was a student at Kennesaw State, star student, A's and B's on the basketball team with dreams for professional basketball. As I said, the facts of the case as she related them to the police, and it bears noting that she spoke to the police immediately without an attorney, and she basically laid out the ability to arrest these other individuals. She went to this place to gamble. Mr. Etienne pulled a gun on her, took her winnings, and she then went to get help to get her winnings back. She did not know that the individuals had guns. The only thing she knew was one of them had.
You're telling me a long gun in the car? Nope, she didn't know anybody had guns?
The long gun was a fake gun. And what I was getting ready to say is she knew about that because she saw that one, but it was a fake gun. And
what did she think they were going to do? She gambled with the victim. Is that correct, Mr. Abadi?
She gambled with the victim. Yes.
All right. And so what did she think? The victim was just going to hand over the money free and willingly? I mean, she gambled and she lost.
She was hoping that men would be able to have better luck with getting the money back than women. That she's much smaller, she's much slighter. How
you gonna get a jury to buy that?
Well, Your Honor, right now, I wish we had a jury, but we don't have a jury and we're not in a jury position. We're here to show the court that there are Ayala factors that have been met.
Well, your client admits that she gambled and she lost. She picked up these gentlemen to go get her money back. And she didn't think that violence would occur?
No.
Why would she think she's entitled to her money?
She's entitled to her money because she won.
Frozen?
Your Honor, I would ask that I not be interrupted by victim's family at this point.
No interruptions.
Mr. Etienne had a gun. She was intimidated by that. She did not think that the men would be as intimidated, and she thought she would get her money back. I would note, Your Honor, that all this talk about gang members, my client is not a gang member. She never was. The picture that Mr. Abadi keeps talking about is a picture of when she was a child, and they are not gang signs. They are, as I think I've said that before, children seem to think even today that throwing gang signs or throwing signs with their fingers is cool. It's done on every social media post that you see. You can pick up any social media of a teenager and see them throwing up what look like gang signs. She is not a member of a gang. She has no record. She cooperated with the police. She's not a risk. Nobody has shown that she possessed a gun, that she was a risk to anybody to reoffend or to commit any further crimes. And to keep her in jail at this point with COVID going, she's at the Union City Jail, not accessible, not easily accessible to me, but certainly accessible to the virus. And we don't know when we're going to have a trial. So what we're talking about is holding somebody indefinitely who meets the Ayala factors. I am sorry for the victim's loss. I know it hurts, but the bond factors are the bond factors, and that's what the court should be looking at. And we have met those factors.
All right, let me talk to the lawyer for Mr. Cortez. Who is that?
Good morning, Your Honor. Ms. Primovic for Mr. Banks.
Is it Cortez Banks?
Yes, Your Honor.
All right, Mr. Abadi.
Mr. Banks.
I'll come back to you, Ms. Primovic. Mr. Abadi.
Yes, sir.
Tell me,
Yes,
how certain are you and your investigators that these defendants, including Ms. Street, are in a criminal street gang?
They are very certain that the young men are in a criminal street gang. As Your Honor is very aware, I don't have to prove that Miss Street was in a gang, just that she was associated with members of a gang, which I can clearly prove, as she went and picked up 4 gang members to then go shoot and kill Mr. Nashim. So that I can prove beyond, all doubt as it pertains to that fact. I'd also bring to Your Honor's attention that Mr. Nashim has never been accused of having a firearm. He wasn't found with a firearm, and no one from the party in which Detective Schwall'S interviewed, the party where the gambling was occurring, said that Mr. Nashim ever had a firearm or brandished one. I would bring to the court's attention that the majority of the incident is on the video, and there is no gun seen taken off the body of Mr. Nashim. So I would dispute that fact highly, and I think that's more an excuse to try to, I guess, mitigate the reason she brought these 4 individuals who were armed to get her money back and shoot and kill Mr. Nashim.
Ms. Primovic, hang on, Ms. Moe, please. Ms. Primovic.
Thank you, Your Honor. Mr. Banks is 23 years old. He made it to the 12th grade. He was living with his mom and his brother and his auntie down on Fairburn Road. He was working at his GED in Atlanta Area Tech, and only has a couple more tests to take to get his GED. He was arrested on July 22nd of 2019, so he has been in jail almost a year awaiting this case. And like what has already been said, this is going to be a long time until we can get this case in front of a jury. Mr. Banks is on probation in Cobb County, Your Honor. We don't believe he's a risk of flight. He's born and raised here. He's not going to obstruct justice. Mr. Banks is adamant that he does not know. Well, the co-defendants are all in jail. He does not know the co-defendants. He does not know, definitely does not know Mr. Etienne. So he would not be a risk of intimidating any witnesses or obstructing justice. He has the 1 prior felony from Cobb, and then 1 here lately in Fulton. But Your Honor, we still believe that he would not be a risk of committing further felonies if we can get him in an ankle monitor, if we can lock him down on a curfew, basically be locked home with an ankle monitor. He can only leave to go to church or to medical or to court. And that's what we're asking for, Your Honor, for Mr. Banks.
Thank you, Ms. Primovic. Mr. Abate, it's the state's position that Ms. Street organized this, and she was the motivation and the impetus for this action, and that Mr. Banks was the gunman.
That's correct, Judge.
Ms. Moe, you wanted to say something?
Yeah, what I wanted to say was that with regards to association, Your Honor, if we were all guilty by association, I don't know what we would do in the society, but to say that because she knew these people, that makes her not qualified for a bond, I would submit to the court is illegal. She has met the Ayala factors, all of the Ayala factors. The fact that she knew these people does not make her a gang member. The state showed a picture to the court and a court picture and tried to say that this was a picture of her as an adult. It was a picture of her as a child. And I would remind the court that she has met the Ayala factors, and I am concerned about COVID, Your Honor. I'm concerned about how long this is going to last. She has not made any phone calls threatening anyone, and that was the court's concern at the first hearing. That's why we're here at the third hearing. I would also add, Your Honor, that we've got pictures of the victim flashing signs as well. This is not the place to talk about that. What we're talking about here is, does she meet the Ayala factors? Is she a risk? And she's not a risk. Her mother is in town. She can't go anywhere. She has no means to go anywhere. The family is out of town. They're in another state. There's nobody to threaten. She hasn't evidence that she would be a threat to anybody. It's going to be a long time before we get a trial. I think it's only fair that a reasonable bond be set.
Mr. Abate.
Yes, Judge.
Let me go back to Ms. Mull. How old is your client today, Ms. Mull?
She's 20 years old.
All right, and Mr. Abate, how old is the picture that was posted with her and the gang signs? Was it just one picture?
It was a few pictures, Your Honor, and it was not from when she was a child. I don't remember the exact date, but it was within the year that the incident had occurred. And the pictures and the text messages where she's selling firearms as well as marijuana was the day before and the day of the incident, which make her a serious risk of committing felonies pending trial if released on bond, Your Honor. And like Your Honor stated, I'm sorry.
I'm sympathetic with the concerns about the coronavirus in the jail, but on the Ayala factors, I think anybody that's in a criminal street gang or associated therewith, which I believe the state has some at least probable cause of that. Is that correct, Mr. Abate?
Yes, Judge.
I think anybody that's in a criminal street gang is going to commit violent crimes. And I'm very concerned that she was selling guns. I'm very concerned that Mr. Banks is on probation and has continued to violate the law. And if you are in a criminal street gang, I believe you're going to commit serious violent felonies. And the next point I want to make is we need to send a strong message in society that if you have guns and you're in a gang, you're gone to prison. So this is the final bond hearing before this court, and bond is denied to both defendants. What's the next case? Thank you, Ms. Mull and Ms. Primovic.
Thank you, Your Honor.
That completes
Give
my
me a call,
business.
Mr. Banks.
We have position number 3 now, Judge.
Thank you.
Number 3?
Is that's Rockmore, correct?
Yes, ma'am.
Okay, thank you so much.
You're welcome.
Let me get the victim in.
Ms. Mull can be excused. Okay, Ms. Primovic's gone too. Who's the attorney here, Max?
No, Ms. Primovic is still here, Judge. Let me clear out.
I'll be back for another one. I was just clearing up your screen, Your Honor.
Thank you.
I'm still here though, Judge. I'm still
Family
here.
members can go. This gentleman can go. This lady can go. Ms. Hubbard and Mr.
Anyone that's here for the state of Georgia versus Cortez Banks, Kamaya Street, victims, family members, thank you for joining us today. The hearing is over. You can leave the Zoom room at this time. Thank you so much. Be safe. Go ahead, Judge.
All right. Who is the lawyer for Mr. Rockmore?
I am, Judge. And,
all right,
and
remind me, Miss Chenault.
Yes, Judge.
The case?
Yes, it is, Judge.
Please tell me the alleged facts or tell me, remind me of what's going on.
Yes, Judge. Mr. Rockmore took a plea in this case. The last time we were in court, he was sentenced to 5 years to serve 1 with the balance on probation. We're here today for a restitution hearing. The victim of the owner of the car that he was caught in, she is here. She's the victim on that particular charge, and she is seeking restitution for damages to our car.
All right, where is the victim?
It looks like she's trying to get in, Judge. She was here earlier. It looks like she's still connecting to auto. She might have to, I think she had to go out and come back in. She's at work.
This is the case, Max, where you got the kidnapping and other bad charges removed.
It is,
So
Judge.
you did a great job for your client in that case. Is Mr. Rockmore on?
He is, and so, Judge, this is where we're at. The alleged, well, the victim in this case, she provided the state with receipts. There's a 2003 Acura. Hold on. There's a 2003 Acura MDX that has 208,000 miles on it, and that was the car that was taken. It's an older car, it's a high mileage car. The state has sent me receipts which total $2,515 that were repairs done. The blue book value of the car at that mileage, when I looked it up today, is $3,176. Now, where we are is I've talked to Mr. Rockmore. Mr. Rockmore is very appreciative of my work, of your mercy, Judge, of the state's willingness to come to the conclusion that there was no kidnapping. So he's not complaining. He's not a complainer. And I've actually said to him, we had a meeting, and I made the point that, you know, obviously this woman, this lady, Miss Akpala, is not part of any prostitution or drugs or anything else that was happening in that day. She's an innocent victim, and that she deserves to be made whole. So we're coming to this hearing with that complete understanding that she deserves to be made whole. The legal question is this, Judge, and as a lawyer, I kind of have to focus not only on common sense, but also the legal issues involved in the case. She's entitled to restitution. She's provided documentation of $2,515. I think the state's asking for the Kelly Blue Book value of the car, which is $3,176. I don't think legally that's really the question. And I mean, that would be, if the car was not operational, then she would probably be entitled to that. But the car is operational. So my understanding of the law is she should be entitled to be paid back for the amount that she paid in repairs, assuming it didn't Kelly Blue Book value. Now, all that being said, Judge, I've talked to Mr. Rockmore, and he's a reasonable person. I'm trying to be a reasonable person, and we're just going to leave it in your discretion to do what needs to be done legally.
What was your number opposed to the Kelly Blue Book number? What was your number?
Well, the Kelly Blue Book value is $3,176. The repairs is $2,515.
Well, can we just split the difference and go to $3,000?
So, Judge, if I could just interrupt a minute, Miss Akpala actually says that she spent over $6,000 in repairs on this car. However, she was not able to get all those receipts at one time. These are the only receipts that she could find. So I said, well, okay, let's just ask for the Kelly Blue Book value since you don't have, you know, all these receipts totaling $6,000.
I think that's a fair resolution.
Yeah, so that's
okay. Like I said, I'm just leaving it in your discretion, Judge. But I think, you know, I think legally, you know, if we're going to focus on the legal part of this, you know, it's on them to prove the cost of the repairs, and it would be the cost of the repairs that's.
Well, let's say the car is total.
Judge, I'm leaving it completely in your discretion.
Where
Mr.
is-
Rockmore, is that fair?
Yes,
Is that
sir.
fair, Mr. Rockmore?
Yes, sir.
Okay.
Where is the lady?
I'm here. I don't know if y'all can hear me. Can you hear me?
Yes.
Okay. I don't know why I'm not showing.
Are you able to put your video on, Miss Akpala?
I'm trying to, says video, start video. Okay, let's see.
There you go.
Okay, thank you, sir.
I think the maximum under the law that you could get is the Kelly Blue Book value of the car. Because I would have imagined at the time, an insurance company would have totaled the car since it had such significant damage. And I understand you spent $6,000 trying to repair the car, but maybe the prudent thing would have been to find another car that you could have bought without having to spend that kind of money. I'm certainly not excusing the fact that you are a victim and that this was a horrible thing to happen to you and your family. I believe that the defense will acquiesce to the court for the Blue Book value of $3,176 as your restitution. Okay, ma'am?
Thank you, sir.
All right, so let's back, Ms. Chenault, will you submit me an order to that effect?
Yes, sir.
And just put in there that the defense had no opposition. I'm not gonna say they consented, but they had no opposition to the entering of that order. Good luck to you, ma'am. All right.
Thank you,
Clark.
sir.
What's
Ms. Clark,
next?
do you need to, wait a minute, Ms. Clark, do you need to speak to the victim or Ms. Chenault?
I think you ought to put Ms. Clark, I don't know, I think you just put Ms. Clark and the defendant in a what do you call it, a side room?
You
Let's
need a
put Ms.
defendant, Ms. Clark? Okay, all
And
right.
the
I want to,
defendant in a side room.
okay.
right, what's
That
next?
is Marietta Annex.
Not the, I'm sorry, not the victim. I need Miss.
Not the, I need Ms. Clark, Ms. Clark.
Who do you need?
You have a way to contact the victim?
That's why.
Is she still, you need to
Ma'am, the
talk to
victim?
her?
Yes.
Okay,
Ma'am, where do you, Miss, I can't see you, ma'am.
I've already done it.
And this, ma'am.
Okay. I just,
Okay, you
hopefully
got
she'll go to the Zoom room. Okay. All right, let me see who else we have on here, Judge. I have Miss Winfrey, I have Miss Primovic. I just need, hold on.
Mr. Moses.
I need Mr. Moses. So give me just a second. Let me see if I can get One North online. And will that be our last jail case? I think so.
Yeah,
Hold on.
that's all I have. Moses
All
Hamilton.
right, thank you. Hold on.
What are we doing on Mr. Hamilton, Ms. Primovic? What in the world? Okay.
Your
Marilyn,
Honor, we started, yes, sir. We started a plea a couple weeks ago, and there was mention of jail phone calls, and you wanted to hear about those and hear them if we could.
okay, can you?
So we're in the same. We still need to go over his rights and everything.
This
if
is
the plea goes through.
Miss Winfrey.
Good morning, Judge.
Correct, Your Honor.
Good morning. We were trying to do a deal in this case, weren't we?
Well, so this is the case that, if you recall, we already had a bond hearing about this and the victim was present. And this is the case that there was an aggravated assault, family violence with the father of the child. This was done in front of the kids where he beat up the mother of the children. And we talked about him making phone calls to the victim continually. And you wanted to hear some of those jail calls.
The victim recanted, right?
Yeah, initially she said, no, I don't want him out of jail, I'm afraid. And then we came back to court and she indicated that she was wanting him out to help take care of the family. And now we're at a place where she sent me a statement to read to the court. She didn't want to be on the Zoom call today. She does have an ailing father who's dying, and so she's going through that and then the stress of this case. But she did send me a letter and a statement to read. She's back to her original position in terms of he needs to be held accountable to the things that were done. I did also talk to Brandon Hamilton, who was the 16-year-old victim in the case, and I have his feedback also that I can share with the court.
Please do so. You may
Okay.
proceed.
Okay.
Your Honor,
Do we
can
want to wait for the defendant
Right.
to be
Yes.
present, please? Thank you.
Thank you.
Sorry about that, Ms. Sanders.
Ernell, please remind me of the deal that was offered in this case.
The deal that was offered is 20 years to serve 2 in confinement, balance on probation. He is to go through family violence intervention and anger management. And until that time, he's not to have any contact with the family. Once that's completed, no violent contact with the family. I'm sorry
for interrupting you through.
And
the victim say that she wanted to be with him, or she's afraid of him. She's flipped on her position, right?
yes, and when that defendant gets on the phone, I can read that. Yes, she's gone back to her original position from when we had the bond hearing.
Do they have children together? Please remind me.
They do, Judge.
How old are they?
So the children are, so there are a total of, there are 6 children. 3 of the children are his biological children. Noah Hamilton is 4 years old. Jordan Hamilton is 3 years old, and Bentley Hamilton is 2 years old. The 16-year-old is not Brandon Hamilton, is Brandon Harley. He was 15 at the time of this. He's 16 now and going to the 11th grade. He was the one that the defendant choked and strangled as Brandon was trying to intervene when he was beating up his mother. When the defendant was beating up
April?
Yes, Judge.
Are we waiting on the defendant to get on screen?
Yes, Judge. They were on their way down with him moments ago, so it shouldn't be too much longer. We do have 2 more cases that are scheduled for the afternoon. I can call to see if I can get them moved up if you like.
No,
they are private attorneys.
Is this the last case for the morning?
Yes, sir. And then there's just 2 cases for the afternoon.
All right. So the afternoon starts at
2.
2. Okay, that's
and I can move that up if you would like.
No, let's not do that. I've got a meeting I have to be at 12:30. All right, Mr.
So this is our last jail case.
So at 2 o'clock, I just see 8 and 9, those 2 positions, right?
Say it again. Okay, here we
Only
go.
2 positions. Only 2 positions at 2 o'clock.
Yes, that's the state of Georgia versus Maurice Jones, and then the add-on, because the Perry case was further notice they couldn't reach a resolution, and our add-on case is Glenton, Brazil.
Glenton.
It's an add-on. Yes, Judge. It's 20 SC 174395, and we thought that we would end our criminal calendar season with Miss Rockwell at 3 p.m.
I thought, is that Glenton, Brazil?
Yes, Glenton, Glinton.
Let me ask you this. I thought we were going to handle Bruce Harvey's case before we left.
I did not. Well, I was waiting on a call from them in regards to whether or not they had reached a resolution in the matter. Because remember, we were waiting for the state to give discovery to Mr. Harvey. So we have that. So Mr. Harvey has received that. And I believe we're waiting on Dr. Norman to talk to everybody that he was supposed to talk to. And so at this point, I don't think that there is. I did receive an email from them today. Let me open it up and I'll summarize it. He's saying there's no resolution in the case so far. That's where they are.
Continue to work towards a resolution?
Yes, Judge, we are working towards it.
All right, let's do this. All right.
Somebody is here from the jail. I can't remember who it was.
But I'm gonna keep that case over Miss Wood's objections to see if we can work that out, Miss Winfrey. And
How long are we going to keep that case, Judge?
you'll see what I have to go through every day. Let's try to see if we can resolve that case by the end of August. Is that enough time?
Understood, Judge.
Will you let Mr. Harvey know that?
I will know. I will let him know, Mr. Judge.
Okay.
Let him know.
Let's connect the jail, please.
I thought I did. That was just, I just let somebody in from the jail. Maybe they got kicked out. Maybe they're trying to get back in. Ms. Blake, do we have any more victims? Okay, here's 1 North coming in now.
Let me double check.
Okay. Access to our video.
There we go.
Okay.
We'll go position number 5.
All right, Mr. Hamilton.
Yes, sir.
All right, Miss Chenault, Miss Winfrey.
Yes, Judge.
Those jail tapes, we're gonna hear them, but can you summarize the substance thereof?
So, Your Honor, I have one set of jail CDs. There is one call that was made. I don't know who the caller, I don't know who the recipient of the call was, but Mr. Hamilton was describing that they needed to make contact with the victim and get her to sign an affidavit to basically drop the charges. The victim actually indicated that there were several calls made to her job. Now, there are a second set of CDs that I do not have that our office has downloaded, but I've not been able to get them until last night when I got the email about having received them, having them being downloaded. So I haven't had those calls to be able to give you a summary of what those are. But I strongly believe that based on my conversations with the victim, that those set of jail calls that I haven't also given to Ms. Primovic, I need to give them to her. Those sets of jail calls would indicate and show the interactions between him and the victim. And I don't have those to summarize for the court.
Those were the calls to her employer.
Yes, to her employer. And
she was terminated.
She was terminated from her employment because of those calls.
And she's got 2 children by this gentleman?
She's had 3 children by Mr. Hamilton.
Right. What is her position of when he gets out of jail? What does she want?
Okay. So if I may, I can just read the statement that she provided.
Please.
Ms. Hamilton sent this to me today, June 25th, 2020. Good day. For the past 5 years, my marriage, it has been a roller coaster of verbal abuse, physical abuse, but this last incident by far was the worst. But Moses, Mr. Hamilton, being away, I believe has changed in a way that he needs professional help outside the jail. He still has children that need him, but need him in a positive way. I believe that he needs to go to therapy for himself and a fatherhood program. For his actions were not great, but he is still a good person when everything is good. He has had a rough upbringing, and it is hard to be a father or husband when no one has ever shown you how. Please forgive me for not attending today, but with the seriousness of my father's illness, he is dying, with him and dealing with the case with my husband, it is a lot. Moses, Mr. Hamilton, does need professional therapy where we as a family can work on the issues that has plagued us all with probation for years that will hold him still accountable for his actions. Thank you and have a nice day. And so at this point, she has indicated that she wants him to receive help and assistance with the problems that he has with the physical abuse. I also talked to Brandon today, Brandon Harley, who is the 16-year-old that's the victim in the case. He indicated that on the date that the incident occurred, which was September 29th, 2019, he walked in and saw his mother on the floor in the bathroom, and she was having a seizure at that point, an epileptic seizure, it looks like, and the defendant was hitting her in the face while she was on the floor of the bathroom. He said that he jumped in to try to stop the altercation. That's when the violence turned towards him. That's when he got choked and strangled. But he also indicated that he felt like Mr. Hamilton needed a second chance. He told me that his mother has talked to all of them about getting some kind of counseling for all of this. And that at the time the incident happened, he just wanted to defend his mother. The state's position, of course, is that, as domestic violence goes, when there's a cycle of abuse, there's trauma bonding that happens with the victim and with the defendant. We believe that Mr. Hamilton, this is not his first rodeo or first time, if you will. He's had another family violence conviction out of Fulton County in 2018. That was a misdemeanor offense, and now it's elevated to this place. So our position in that he has one felony conviction, but another one felony conviction, actually 2 felony convictions. One was actually a first offender, so it's not really a conviction. We believe that his violent behavior won't end until he does have some kind of help, which is why we're asking for him to take anger management, family violence intervention. But at the same time, we believe he should serve some jail time. 20 years to serve 2 balance on probation. That is our recommendation to the court.
Hamilton, you wanted to address the court?
Yes, sir.
Mr. Hamilton, do we need to chat before you talk to the judge?
I mean, if you want, it don't matter.
Yeah, Your Honor, what we're asking for, and Mr. Hamilton agrees, and I spoke to his wife a number of times. We're asking for, he's been in since September of 2019. We're asking for time served in probation, where he would have to go to Men's Stopping Violence program, be evaluated, and go to counseling. They also have a fatherhood program. We think an intensive counseling is what he needs, a little bit more than longer and intensive. He'll get mentors, he'll have counseling groups, he'll get individual counseling at Men's Stopping Violence, a little more intensive than the normal violent counseling that we give through probation. He was and saw such actions as a child. He had a difficult upbringing, like we've already heard. So that is what we're asking for, Your Honor. Mr. Hamilton, do you have anything more to say than that, sir?
I just want to say that the family violence conviction charge that I do have, that was because of my sisters. Her lover, they threatened to kill my kids. And I didn't physically harm her. I shoved her to get her away from my kids. That's what happened in that incident, sir. But I never been a physically abusive person towards my wife. Now, we may have had verbal disagreements, but as far as me just hitting her repeatedly, that never happened, sir. When my son walked in that bathroom that day and saw my wife in there, I wasn't even in the bathroom.
It sounds like to me we just need to enter a not guilty plea and have you go to trial.
You said go to where, sir?
It sounds like to me you're telling me you're not guilty of the charges.
No, sir. No, sir. I'm most definitely guilty, sir. It happened. The incident did happen, but it wasn't to the extreme of how the DA is putting it. But it most definitely happened, sir. And I am most definitely guilty. And I'm sorry for the case that happened in that situation. It most definitely happened.
We got to ask you one word. Why? Why did it happen? Why did she get attacked? Why? What was your impetus for that? What was your motivation? Because society will not, and this court will not tolerate domestic violence.
I understand. I totally understand that, sir.
You got to ask yourself, what went through my head that made me do that? Especially if she was on the floor having an epileptic seizure. Let me turn to Ms. Winfrey.
He denies. He denies that part, Your Honor. He doesn't deny the beforehand.
Miss Winfrey,
Yes, Judge.
does she want him to come back and live in the home with her?
She honestly is indicated to me that she fears that her kids could potentially be taken from her if she allows him back in with her. And there's another episode because of her failure to protect her children. So on one hand, I'm sorry, sir.
DFAC's been involved?
DFACS has not been involved at this juncture, but she's afraid that it could escalate to that level. Now, she's indicated that her children need him as a father, but not in this way. She's not indicated that he's moving back in with them, or but I can tell that she's afraid that if this continues without him having some kind of assistance or help, that it could escalate to a point where she's now negligent for going back to him after this violent episode.
Is she in fear of her safety, as far as you know, about him getting out of jail at some point?
He's not indicated that to me, no, Judge.
He has not. The answer to that question is no?
No.
Where are you going to live if you get out, Mr. Hamilton?
I have a mom and a sister, sir, I can go stay with.
Do you realize that this probation is going to be rigorous? Okay, and you'll be on probation for a long, long time. And the new judge taking over this case is Judge Whitaker, and she's tough. She doesn't play. I'm tough, and I don't play. And I'm going to ask that this probation be returnable directly to this division, whether it's Judge Whitaker or me. And there are no third chances with me. Do you understand that?
Yes, sir.
And I think it's very important that you be a good father. And I think that we're going to have strenuous anger management, domestic violence counseling. I want the most strict, stringent counseling out there. Blake?
Yes, sir.
Can you tell me we have programs in probation of very rigorous, lengthy counseling sessions to help prevent this happening again?
Your Honor, from my research, the Men Stopping Violence program has at least a 24-week educational course. And from my research and talking with my social workers, those seem to be the most stringent and all-encompassing, because sometimes there's some mental health issues, there's some personality disorders, depending on who they are, that they evaluate and that they can hook them up for fatherhood programs. So from my research, it seems to be Men Stopping Violence, unless probation or the victim advocate has any other ones that they know about.
Mr. Hamilton?
Yes, sir.
I assume that since you have children, 3 with the victim, that you love her and you love those kids.
Yes, sir.
Well, you have to ask yourself, why would I harm somebody that I love, the mother of my children? You have to ask yourself that, because society will not ever tolerate this. Here's what we're going to do. You've been in jail since September?
Yes, sir.
Yes.
What is the date, Ms. Woods?
He's been in custody since September 29, 2019 is what I have, Ms. Permavic.
I'll take 20 to serve 1. Balance probate, all that anger management, Men Stopping Violence. I'll commute the 1 to time serve. Are you married to the victim, sir?
Yes, sir. I've been married. We've been together 7 years. I've been married 5 years.
Ms. Winfrey, has she indicated that she wants to stay married to him?
She has not indicated to me either way or the other, Judge.
And Your Honor, from my conversations, she stated that she sees the potential in Mr. Hamilton, but without counseling and work on his part, they will eventually divorce. So if he gets his stuff together and does what she knows he can do, because he's a really good father, and like we've already heard, she's a really good husband until these triggers hit, and he needs to really work on these triggers through these programs. And Mr. Hamilton wants to do that.
What part of town does she live in, Ms. Winfrey?
She actually, she's now moved into a home as actually, when I talked to them today, I don't have that address. I need to get that address, Judge.
Where are you gonna live, Mr. Hamilton?
It's off of Jonesboro Road. Off of, I want to say it's 134 Jonesboro Road, sir.
Are you gonna have to give the probation officer, after we handle this, your address and phone numbers?
Okay.
And should we
Judge,
do an order? Go ahead.
And
Ms.
Judge, if I may, the state will insist though that normally we ask for no contact provision, but under these circumstances, we're asking that he have no contact with the victims until and unless he successfully completes the programs that Ms. Primovic has indicated. And upon successful completion of those programs, then he could have no violent contact.
So until he completes the programs, it's no contact. You understand that, sir?
Yes, sir.
So you have a motivation to do this as quickly as possible. So there'll be no contact whatsoever until he's completed the courses. But a condition of the probation will be that he support these children with a 40-hour-a-week job. You understand that, Mr. Hamilton?
Yes, sir.
He has a lot of jobs, Your Honor. He's a worker.
All right. I want the children supported, and they deserve a good father, and they deserve a good emotional relationship with you. And you have to decide whether or not you're going to do the right thing. Because if you don't, your probation can be revoked. And if I'm the judge, it will be revoked. And I don't think Judge Whitaker would think any differently.
Do you have any problems with him talking on the phone? Because I think the youngsters are going to want to talk to him on the phone. Do you have a problem with that?
The children on the phone, and then he can see them after he gets these courses done. All right.
And Your Honor, also the stay away, she's texting me her information now. I would also ask that he stay away from her job, her current job until,
You understand that, Mr. Hamilton?
Yes, sir.
All right, Mr. Hamilton, please raise your right hand. Do you swear or affirm the testimony you'll give before this court is the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Ms. Primovic, have you discussed today's proceedings with your client?
Yes, sir, I have.
Does your client fully understand that he would be appearing by Zoom and not be physically present in the courtroom?
Yes, sir.
Did you obtain a waiver, whether verbal or written?
A verbal waiver, Your Honor.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes, sir.
Yes, sir. We both do.
All right, now, Mr. Hamilton, have you discussed today's proceedings with your attorney? You can put your hand down.
Yes, sir.
Have you discussed today's proceedings with your attorney?
Yes, sir.
Has your attorney explained to you that you have a right to be physically present in the courtroom?
Yes, sir.
Do you waive your right to be physically present in this courtroom today?
Yes, sir.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes, sir.
Ms. Winfrey, does the state waive an original signature on the indictment and authorize the court to sign on his behalf?
Yes, Your Honor.
Mr. Hamilton, the outline of what I've discussed, is that what you're willing to plead to?
Yes, sir.
All right, y'all may proceed to perfect the record. Thank you.
Thank you, Judge. Mr. Hamilton, will you please state your true, correct, and legal name?
Moses Malone Hamilton.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far did you go in school?
31 and I completed the 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged or being charged with the following offenses? You're being charged with count 1, cruelty to children in the first degree, count 2, aggravated assault, strangulation, family violence, count 3, aggravated assault, family violence, count 4, terroristic threats, count 5 through 10 are all cruelty to children in the third degree. Count 11 is hindering a person making an emergency telephone call. Count 12 is criminal trespass in indictment number 19 SC 173107.
Yes, ma'am.
Do you understand that you have a right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Ms. Primovic, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
That depends on my. Yes, ma'am.
So you need more
I mean,
time?
No, I don't need more time. Do you want to talk to me, Ms. Marilyn?
No, I just want to say, Mr. Hamilton, at any time, if something confuses you or you don't know, just say you need to talk with me and we'll go into a breakout room, okay? And we're going to talk after with probation about everything when it's all over. Me and Miss Clark and you are going to talk afterwards. But while this is going on, if you ever have any questions about something or you're confused, just say it and we'll go in a breakout room and talk, okay?
I understand.
Okay, sir. Thank you.
So, Mr. Hamilton, I'll ask you that question again. At this juncture, do you need more time to discuss the case with your lawyer?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Okay. Counsel, do you waive formal reading of the indictment?
So waive.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
Yes, ma'am, we do.
Mr. Hamilton, have you been arrested on these charges?
Yes, ma'am.
The reason why the state asked that question is the state is unaware of any outstanding warrants that are related to the charges in this indictment. Do you or your attorney know of any outstanding warrants that are related to the charges in this indictment?
No, ma'am. Not to my knowledge.
Ms. Primovic?
No, ma'am, I know none.
Okay. Has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to today?
Yes, ma'am.
For purposes of the record, I want to perfect that. I want to place it on the record what the sentence range is for each charge. Count 1, cruelty to children in the first degree, carries a minimum sentence of 5 years, maximum of 20 years. Count 2, aggravated assault, strangulation, and count 3, aggravated assault, both carry sentences of a minimum of 5 years, maximum of 20 years in confinement. Count 4, terroristic threats, carries a minimum of 1 year, maximum of 10 years in confinement. Count 5 through 10, which are all cruelty to children in the third degree, each carry a minimum of 1 day to 12 months in prison or in jail and confinement. Count 11, hindering a person making an emergency telephone call is a misdemeanor that also carries a minimum of 1 day to 12 months. And count 12, criminal trespass, carries a minimum of 1 day to 12 months. That is the minimum and maximum sentence for each charge you are pleading to today. Do you understand that?
Yes, ma'am.
Do you understand that if you are, I'm sorry, strike that. Do you understand that if you are, if your guilty plea is a blind plea, this is a non-negotiated plea, the state can still make a recommendation to the court and the court does not have to accept that recommendation. Do you understand that?
Understand.
Okay. And do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
And do you understand that if you enter a non-negotiated plea, you do not have the right to withdraw your plea once the sentence has been announced?
Understand.
And do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including federal courts?
Yes, ma'am.
And do you understand that if you are currently on any kind of probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would? And this is true regardless of any advice given to you by your attorney or anyone else.
Yes, ma'am.
And do you understand that neither the court nor your attorney, nor the district attorney's office has anything to do with parole or the Department of Corrections or boards of pardons and paroles, and no one can guarantee parole no matter what anyone has told you.
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of your entering this guilty plea, just as there would be following a conviction after a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain or maintain employment.
Yes, ma'am.
And do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea today? Do you understand?
Yes, ma'am.
And do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, the right to testify or to remain silent and not incriminate yourself? Do you understand that you're giving up those rights?
Yes, ma'am.
And do you understand that by pleading guilty, you're also giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after trial. Do you understand you're giving up these rights, sir?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
So it's your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
All right. So how do you plead to the charges of, as outlined in indictment number 19 SC 173107, count 1, cruelty to children in the first degree?
Guilty.
Count 2, aggravated assault, strangulation, family violence.
Guilty.
Count 3, aggravated assault, family violence.
Guilty.
Count 4, terroristic threats.
Guilty.
Counts 5 through 10 are cruelty to children in the third degree.
Guilty.
Count 11, hindering a person making an emergency telephone call.
Guilty.
And count 12, criminal trespass.
Guilty.
Is this guilty plea freely given and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file what's called a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
For the record, actually, need to call Judge Schwall. While we're doing that, I'll place on the record what the state's recommendation would be in this case. Although this has been a non-negotiated plea, the court has already announced what it would do. But for the record, the state would put on the record that as to count 1, with 20 years to serve 2 years, the balance on probation to run concurrent with the sentence that the state would recommend for count 3. Count 2 would be 20 years to serve 2 balance on probation. Count 3 is 20 years to serve 2 with the balance on probation. Count 4 is 5 years to serve 1 with the balance on probation to run concurrent with count 3. Count 5, 12 months to serve to run concurrent with count 3. Count 6, 12 months to serve to run concurrent with count 3. Count 7, 12 months to serve to run concurrent with count 3. Count 8, 12 months to serve to run concurrent with count 3. Count 9, 12 months to serve to run concurrent with count 3. Count 10, 12 months to serve to run concurrent with count 3. in count 11, 12 months to serve to run concurrent with count 3, and count 12, 12 months to serve to run concurrent with count 3. That will be the state's recommendation in this case.
All right. We've been through the facts. The facts are also on the record in a previous hearing. Is that correct?
That is correct, Judge.
Okay.
But I would also like to perfect the record as to one matter as to count 12, which is criminal trespass. Normally we request restitution. There was a cell phone in this case that was destroyed by the defendant, that the victim actually sent in information to indicate that the price of that, or the value of that cell phone, was $329. That state would be requesting restitution in that amount based on count 12 in the indictment.
You understand that, Mr. Hamilton?
Yes, sir.
Ms. Primovic, is that okay with you?
That's fine, Your Honor.
All right. Mr. Hamilton, you're under oath. Do you understand the nature of the charges against you?
Yes, sir.
You understand all the rights you're giving up today?
Yes, sir.
And are you freely, voluntarily, intentionally, and knowingly waiving and giving up all your rights?
Yes, sir.
Is counsel satisfied that your client is competent and understanding that the plea is voluntary and that there is a factual basis and that he's freely and voluntarily waiving his rights?
I do, Your Honor.
I will accept the plea as enunciated by the state, agreed to by the defense, including the restitution. And there's a no contact except by telephone order with the children. He will continue to send child support. I guess you can do that by mail. You understand that, sir?
Yes, sir.
How much child support can you send? Can you send $500 a month?
I mean, I had to get back into my employment stage, but yes, sir, I can.
He hasn't been working, Your Honor, since end of September.
But
so
I'll give him to September 1 to make his first payment. That'll be $500 a month by certified funds, money order, or a cashier's check. All right.
And Your Honor, we would ask that these conditions that the court is enunciating would be ensure they were special conditions of his probation.
All right. That's fine, Ms. Clark. Is that okay? All right. Now, I have done this because of the input from your son and your wife. And I think it's imperative that you support your family, you do the right thing, no further violence, and that you be a good husband and that you be a great father. Okay? And it's my understanding that you have those abilities and that you have shown those abilities. Okay? All right, let's get it right. All right, let's come back for the 2 o'clock calendar and y'all take care. Thank you.
Thanks, Jeff. Can we have a breakout with Ms. Clark and Mr. Hamilton?
Sure.
Please? Thank
Not
you.
a problem.